Hi, and welcome to the webinar this afternoon presented by the Council of State Governments and the Association of Air Pollution Control Agencies. Our webinar is on the topic of what's next, legal perspectives on the Clean Power Plan. My name is Clint Woods. I'm the Executive Director of the Association of Air Pollution Control Agencies, or APCA, and I'm joined in moderating today by Liz Evenson, the Director of Energy and Environmental Policy at the Council of State Governments, or CSG. We've got a really distinguished panel of experts to discuss the Clean Power Plan and legal challenges. And I want to just express my appreciation to them for joining us and also for all the attendees. Before we get to introducing them, we have a few quick notes. We're going to be pursuing a slightly less traditional format on today's webinar. We have scheduled approximately 75 minutes, about until 4:15 Eastern. So as part of the discussion today, we're going to have brief comments here at the start just on housekeeping items and a brief summary of the Clean Power Plan. We'll introduce each panelist and provide them with 5 or 10 minutes to provide their perspective. And then we're going to turn things over to Liz to ask a few questions that we submitted in the advance to the panelists and have them respond in a roundtable fashion and expand and discuss upon their initial comments. And then finally, at any point during the webinar, you can submit questions in the text box on your GoToWebinar frame. And at the end of the webinar, we should have 15 or 20 minutes or so to pose those questions to the panelists. So I wanted to real briefly just discuss CSG and APCA and give you some perspective about our organizations. The Council of State Governments, or CSG, is the nation's only organization serving all 3 branches of state government. It's headquartered in Lexington, Kentucky. It's a nonpartisan, region-based forum that fosters the exchange of information. And just as an additional plug, if you're interested in a related topic, CSG and CSG West will be offering a webinar tomorrow on species conservation that will feature Wyoming Governor Matt Mead, so you can register for that on the CSG site. As for APCA, we're an affiliated association with CSG. We're a consensus-driven group that serves state and local environmental agencies, and in particular their air quality divisions, on technical Clean Air Act issues. Our 18 state agencies that serve on our board of directors have primary responsibility for air quality for a portion of the country that represents roughly 40% of U.S. population and over half of U.S. electricity production and consumption. So obviously have great interest in the Clean Power Plan. Just a couple additional notes. CSG and APCA are not involved in any legal challenges involving the Clean Power Plan, and obviously have a number of state members with diverse perspectives about the rule as well as the litigation. APCA has not taken position on the Clean Power Plan as proposed or finalized, or any particular state approach to the rule or to the Supreme Court's recent stay. So I wanted to just mention a few quick items before turning things over to the experts that you're really interested in hearing from. I know we have a very sophisticated audience, including state officials, many of whom have spent dozens of hours on the Clean Power Plan, probably just in the last few months. And in light of that sophistication, I think we're going to make a few assumptions about the audience and about their knowledge about the Clean Power Plan. And we'll rattle through a few of those related to the structure of the rule, some key changes in the final rule, timelines, and some other things relevant to legal challenges. But if you're thinking to yourself, I didn't know I need to do homework before tuning into this webinar, the good news is, first, we'll be posting the webinar and all the slides on CSG's Knowledge Center, as well as the APCA site and our YouTube page. So you can go back and revisit that information. In addition, if you're trying to get up to speed or a little more background information about the Clean Power Plan, there's a number of great resources. CSG's Knowledge Center has a number of blog posts and other information. For APCA members, our APCA members only site has a number of resources, including state-by-state Clean Power Plan information. And just as a plug, that if you don't work at a state environmental agency, those folks who work there have a lot of expertise in this area and are great to ask about your particular state effects from the Clean Power Plan and where we may go from there. EPA has a number of resources, obviously, as the entity that has proposed and finalized the rule. If you go to epa.gov/Clean Power Plan, there's a number of pieces of information and fact sheets. Additionally, there's a state-specific toolbox at epa.gov/Clean Power Plan Toolbox, all one word. Furthermore, if you're looking for some of the briefing materials and legal items that may be discussed on today's webinar, there's a number of places you can look online. The Environmental Defense Fund has a comprehensive set of links to all briefing materials for challenges to the Clean Power Plan. Obviously, our experts on the panel today also have some great perspectives. And as I think a lot of the folks who are tuned in know, there's a number of other materials, including subscription and non-subscription services that provide perspectives, including state-specific information about the Clean Power Plan. So just to rattle off a few of the assumptions that we've asked our expert panelists to make as they discuss their legal perspectives on the Clean Power Plan. I think we're going to assume that everyone knows generally what the Clean Power Plan is, as proposed by US EPA in June of 2014 and finalized in August of 2015, that involves emission rates for fossil fuel fired power plants or electric generating units. Our panelists may refer to EGUs. The regulation is under Section 111D of the Clean Air Act, and the overall goal is a 32% reduction in carbon emissions in the power sector by 2030 from 2005 levels. I think we're also going to assume that folks generally have a knowledge of the structure of the rule, including that EPA determines what's called a best system of emissions reduction that states then have to carry out on a state-specific basis, and that in order to get to those individual state targets, EPA relied in the final rule on 3 building blocks. The first being improved heat rate improvements at coal-fired power plants, second being substituting generation from existing natural gas plants, and the third being substituting generation from renewable resources. I think we're also going to hope that everyone has a little bit of background on some of the key changes that EPA made in the final rule that may be relevant to legal challenges, including the inclusion of blended regional emission performance rates based upon electricity interconnects, and knows that for each individual state they have a state-specific target that may have changed, and in some cases changed significantly from the proposed rule in 2014. I think we're also going to hope that folks have a little bit of background and knowledge of the terminology as it relates to EPA's final rule and how states can pursue statewide goals, either as a rate-based goal in the form of pounds per megawatt hour, a mass-based goal in the form of short tons of CO2, or a mass-based goal with a new source complement. And then I think there's a couple other key assumptions that we're making about folks' knowledge of the final rule, that EPA included 2 types of potential state plans, either an emissions standards plan or a state measures plan, and that the final rule also included some key new changes as it relates to emissions trading via emission rate credits or allowances and reliability. And then finally, that their timelines were updated prior to the Supreme Court stay that there's been much discussion about, that would include state plans, either in a final plan or an initial submittal with an extension request would have to have been submitted to US EPA by September of this year, with final state plans due in September of 2018, and that the compliance period for affected power plants runs from 2022 to 2030. And I think we're also hoping that folks have a little bit of knowledge of a few other regulatory items that have interactions with the legal challenges to the Clean Power Plan, including EPA's final carbon pollution standards for new, modified, or reconstructed power plants under Section 111B of the Clean Air Act, as well as EPA's proposed federal plan and model trading rules that also came out in the middle of 2015, which would be, that federal plan would be imposed if states did not submit an approvable plan to US EPA. I think there may also be a little bit of discussion of a few other programs and guidance documents that are relevant, including EPA's outline of a clean energy incentive program, as well as evaluation, measurement, and verification guidance, or EM&V for energy efficiency. And then I think we're also, our panelists are going to be discussing further some of the interactions and differing views about US EPA's ability to regulate sources under Section 111, if they're also regulated under Section 112. So I think there'll be some additional discussion there. And then finally, the other assumption we're making is that folks are generally tuned into a few recent legal developments and some significant ones that have made this webinar particularly timely. First is the February 9th Supreme Court stay of the Clean Power Plan prior to consideration by the DC Circuit Court of Appeals. Secondly, I think some general knowledge about the changes in the makeup of the Supreme Court recently, including the passing of Justice Scalia and the nomination of Merrick Garland. And then finally, and most recently, originally scheduled for June 2nd before a 3-judge panel of the DC Circuit, oral arguments were going to take place next week. But as a result of a DC Circuit order issued last Monday on May 16th, that oral argument has been rescheduled for an en banc hearing before the full court minus recused judges for September 22nd. So having said all that, and not being nearly as brief as I should be, I want to turn things over to our panelists to talk for a quick introduction of their perspective before we get to a few of the more in-depth questions. And we'll provide real brief introductions for each of them, but you can find more information on their respective firm sites. So first, I'm going to turn things over to Jeffrey Holmstead, who's the partner and head of Environmental Strategies Group at the firm Bracewell in Washington, D.C. Previously, Jeff served as Assistant Administrator for US EPA's Office of Air and Radiation. He holds degrees from Yale Law School and Brigham Young University, and you can read more about Jeff at bracewellaw.com. With that, I'll turn things over to you, Jeff. And Jeff, I think we can't quite hear you. If you want to unmute your line.
I'm sorry. Is that better?
Yep, we can hear you now. Thanks so much.
Can you hear me now? Oh, okay.
We can.
As we were preparing for this webinar, I think all of us agreed that it would be most interesting and most useful to spend most of the time answering questions and talking about some key issues. So I'm not going to give a long presentation about the legal issues and exactly why I think the rule is illegal. I suspect that we'll have some opportunity to talk about those issues during the questions and answers. I wanted to make just a few key points at the outset. The first one is this: the regulatory authority that EPA is claiming under this rule really is quite remarkable and goes well beyond anything that EPA or any other federal agency has ever claimed for itself. And you know, we can talk about the building blocks and we can talk about the way EPA has put this all together, but essentially what EPA is asserting here is that under Section 111D of the Clean Air Act, it can essentially, you know, take a step back, look at the power sector, and say we think it would be cost effective to take about 30% of the business away from existing coal-fired power plants and award that business to different types of plants that we think are a better way of producing electricity. And so in essence what EPA has done is come up with a system that is specifically designed to take about 30% of the business away from 30% of the existing business away from coal-fired power plants and award that mostly to new wind and solar facilities that EPA is requiring be built over the next 15 years. Or put in another way, EPA is basically saying that they have the authority to require a large number of plants to be shut down and to be replaced by new plants that are more in keeping with EPA's view of how electricity should be produced in the United States. That is a remarkable assertion of authority. EPA has never claimed that kind of authority before, and neither has any other federal agency. So you know, some people may argue this is just another EPA rule. EPA does this all the time. That's simply not true. EPA's assertion of authority here is quite extraordinary. But that's not probably the question that people are most interested in. The question is, well, whether that is legal. Is EPA's assertion of authority in this case lawful, and will it be upheld? You won't be surprised to hear that I think it is illegal. And whenever I speak at events, and is very unhappy with me and says, well, how can that be? The Supreme Court has already said in multiple cases that EPA has the authority to regulate CO2 emissions under the Clean Air Act. But and again, probably everybody on this phone realizes this already, but the fact that EPA has authority to regulate CO2 emissions under the Clean Air Act doesn't really tell us anything about how EPA can go about doing that. In fact, the Supreme Court has made it pretty clear that they didn't just give EPA a roving mandate to do good, to do whatever they think, you know, should be done to reduce CO2 emissions. They can only do the things that they can only use the specific programs that Congress has given them under the Clean Air Act. So the question is this rule legal or not, and will it be upheld by the courts? And I would say this: if we could remove all of the passion and all of the concern about climate change from this case, and just give the question to 100 completely neutral judges who simply looked at the structure and the language of the statute and did their best to determine what Congress intended for EPA to do under Section 111 of the Clean Air Act, I don't think it would be a close call. I think 100 out of 100 neutral judges would look at the Clean Power Plan and say it really has nothing to do with what Congress intended for EPA and states to do under Section 111. But we can't remove all the passion and the concern about climate change from this case. In fact, I think EPA has wisely done its best to tell the D.C. Circuit and the Supreme Court, look, this rule is important to the future of the planet and is at the centerpiece of international efforts to reduce greenhouse gas emissions. And court, if you undercut, if you strike down this plan, you will potentially undo this international climate agreement that was reached by almost 200 nations, and so you should think very long and hard before you strike down this rule. And that's just the context in which all of us are operating now, and you know, whether you think that's a good thing or a bad thing, you can't divorce this case from everything else that's going on in this area. So and again, I assume we'll have a bit of time to talk about the specific legal issues, but here's kind of my bottom line. You know, late last year, early this year, when I would sit down and talk with my clients, I would say, and again, this is now public, so I'm not revealing any client confidences. It's very hard to know what the D.C. Circuit is going to do, but if you look at the Supreme Court, we know which we can see which 9 justices we have. We know the way they approach these cases. We can look at their other opinions. And I would say it's hard to know what the D.C. Circuit does, but I would say there's an 80% chance the Supreme Court strikes down the rule. Then after the Supreme Court granted the stay, I was upping that to 90%. And then after Justice Scalia passed away, and the makeup of the Supreme Court changed very dramatically, I think it's much harder to predict what's going to happen. I think it's really much more of a 50-50 case. And maybe that's not the way the law should operate, but again, in this particular case, I think that's really where we are. The other thing I think it's important for people to understand is, in this case in particular, the future of the Clean Power Plan will depend a lot on how the presidential election goes. If a Republican is elected, and I'm not necessarily predicting that will be the case, but this particular rule would be very simple to undo. And I know that you know, some people disagree with that, and I've seen some people assert otherwise. But as someone who has been involved in now 2 different transitions, from one administration to another, from one party to the other, I will say that there are a number of EPA rules that are very difficult for a new administration to change or revoke or really alter in any way for legal reasons or for practical reasons. But the Clean Power Plan is not one of those rules. It would be relatively simple, given the structure of the Clean Air Act, for a new administration to come in and revoke this rule. They would have to do it through notice and comment rulemaking. They would have to explain their reasoning for reversing that rule. But especially in light of a recent D.C. Circuit decision that was authored by Judge Garland, it's pretty clear that it would be relatively simple for a new administration to undo the rule. So I think if a Republican is elected in November, it's quite likely, in fact I would say almost certain, that the rule will be revoked. On the other hand, if we have a Democrat elected in November, he or she will certainly defend the rule and will also have the opportunity to appoint the 9th justice, and that justice, the new justice, will almost certainly be in place before the Clean Power Plan case is decided by the Supreme Court. And then my final point is, if the Supreme Court ultimately upholds the rule, I think if that were to happen, it would happen probably in mid-2018 at some point, and the rule would go back into effect. I do think it's pretty clear that all of the deadlines in the rule would be pushed back by at least the amount of time that the rule was stayed. And I know that EPA and some of its allies have been saying, well, that's not so clear. You know, states, you should continue to working on your plans because those deadlines in 2022 and 2030, you know, they may not be changed, so you better, you know, continue to work hard on your plans. I think that's simply incorrect. There's never been a case where a rule has been stayed, later come back into effect, when all of the deadlines in that rule were pushed back at least by the amount of time that the rule was stayed. So one thing I think is pretty clear, you know, looking beyond all the uncertainty, is if the rule comes back into effect, all of the deadlines will be pushed back by probably 2.5, perhaps even 3 years. So with that, I think those were the key points I wanted to make at the outset, and I'll turn the time back to you, Clint.
Well, thanks so much, Jeff. We really appreciate it. And I think, sir, we're having a couple technical issues here. I think we're going to go ahead, and Brian, if you're okay, we're going to turn things over to you. We've got Sean, I think, had some issues with his phone, so we'll get him back on here. But our next presenter is Brian Potts, who's a partner with the firm of Foley & Lardner based out of Madison, Wisconsin. Brian is a litigator and a business lawyer, and he holds degrees from Centre College, Vermont Law School, and the University of California, Berkeley School of Law. You can find out more about Brian at his firm's site at foley.com.
Thanks, Clint. So I'm going to focus a bit on the procedural history of the case and the likely timing of a final decision. And then I'm going to run through the results of a Clean Power Plan legal survey that a law student and I conducted last year of 141 environmental lawyers and law professors, and talk a little bit about that. If you could go to the next slide, please. So I think it's fair to say that the Clean Power Plan litigation to date has had more unpredictable twists and turns than any prior challenge to an administrative rule has ever had. And we haven't even gotten a substantive decision from a court yet. I just want to quickly run through some of the twists and turns we've seen so far to put some of the discussion in context. So multiple parties challenged the rule when it was just a proposed rule, which is incredibly unusual, and the court denied that. And then multiple parties asked the D.C. Circuit for a stay of the final rule, and the D.C. Circuit denied that. Now that's fairly common. Most of the time the D.C. Circuit will deny a stay request. It has issued stays before. But what was somewhat unusual, or fairly unusual, is the D.C. Circuit issued an incredibly expedited briefing schedule after making the stay decision. And it made it, I got to imagine, very difficult for all the parties, of which there were, I think there's 150 or so, to file briefs together within a short amount of time on a case of this magnitude. So then West Virginia and a number of other parties immediately appealed the stay decision, the D.C. Circuit stay decision, to the Supreme Court. And as everyone knows, the Supreme Court issued a stay. This was highly unusual. I think Jeff was quoted as saying it's the only time it's ever happened, and I haven't heard anyone refute that. It's a really bad sign. This was a really bad sign for the EPA. The only folks I heard, still singing the praises of the Clean Power Plan and saying it was going to be upheld after the stay were EPA and the NRDC. Otherwise, it seemed pretty unanimous that it was, a low likelihood of success. I think Jeff mentioned, 90% that the challengers would win. I'd agree with that. And then Scalia's death changed everything, and I'll talk about that in a second. But after the stay, all the parties briefed the case. It was about to be up for oral argument in early June, and then last week the D.C. Circuit, on its own motion, ordered en banc review, which means all the justices get to hear the case and decide the case, and essentially skipped the 3-judge panel process. And 2 of the judges, and this is important for determining what's going to happen at the D.C. Circuit, 2 of the judges, Garland and Pillard, both of whom were, I think, fairly certain to be in EPA's camp, have recused themselves. So now we're looking at a much more equally divided D.C. Circuit. So what does all this mean? If you go to the next slide, please. Well, with Scalia, it was looking like a 10% chance that EPA was going to win, given the stay decision. With Scalia's death, and I tweeted this out right after his death was announced in the press, and I put the chances at more like 75%. And the reason I did that, and things have changed a little bit, I'd say Jeff said it's 50-50. I'd still say EPA's got a better chance than the challengers, given the makeup of the D.C. Circuit and the 4-4 split that's likely at the Supreme Court. But back when Scalia died, really the only way that I think the Republicans were likely to stop the Clean Power Plan was to both win the White House and get an appointment through in time so that they could have a 5-4 majority on the court. If you could go to the next slide. So, back one, please. So the timing now changes a bit with the decision to go en banc. Now we have arguments in September instead of June, so there's obviously some delay there, but we've skipped a step. So we can expect a final D.C. Circuit decision by, sometime in early 2017. I think it's never been the case where the D.C. Circuit has issued a decision faster than 60 days with a regular 3-judge panel after argument. So with en banc, I think, early 2017 is probably the earliest that we would see a decision. And then there have to be petitions for cert. That takes some time. It's briefing to ask the Supreme Court to hear the case. And then if the Supreme Court were to deny cert, meaning they refuse to hear the case, which I think is unlikely given the magnitude of this case, that'd mean you'd have a final decision, which would be the D.C. Circuit decision, in early to mid-2017. If the Supreme Court grants cert, on the other hand, a decision is likely about a year from then, which would be late 2017 or early to mid-2018. So one thing Jeff said that I think is interesting to think about is most folks are assuming there will be a 9th justice. Either whoever wins the White House will get their appointment through by the time the Supreme Court decides. But one thing to keep in mind is we're in a really unique situation politically where our 3 branches of government are, for the first time in a long time and maybe ever, equally divided. We have a Democratic president, a Republican legislature, and a 4-4 split on the Supreme Court. So we have 3 branches of government that are equally divided. And if that division stays through the election, so if a Republican wins the White House but the Democrats take the Senate, or a Democrat wins the White House and the Republicans keep the Senate, I'm not so sure it's going to be easy for a president to get a 9th justice on the court after the election, and that might end up being a fight, especially because the Republicans haven't acted yet on Merrick Garland. So if you could go to the next slide, I just want to quickly run through the results of a survey we did, and it sort of evidences the 50-50 split that Jeff talked about. We did a poll, a law student and I did a poll back in the proposed rules stage of whether or not the Clean Power Plan was legal as written, and we asked 141 environmental lawyers and law professors about it. This was the demographic makeup, so most of them were private attorneys, but a large chunk were professors. We had a few utilities and nonprofits. If you go to the next slide, the results were almost exactly split. It was 1 vote off between yes, it's legal 1 by 1 vote, and no, it's not was 1 vote less. And then there was a chunk that said that they don't know. The most interesting thing, other than it being so equally divided out of this, is that private attorneys, by an overwhelming margin, over 60%, said it was illegal, but environmental law professors, who presumably taught a lot of those environmental attorneys, thought it was overwhelmingly legal. So, there's obviously a disconnect between law professors and private attorneys. then if you could go to the next slide, my last slide, this shows the results. So of the folks that said it was illegal, we also asked them why they thought it was illegal, and they could pick any of these or all of these reasons. So A is that the Clean Power Plan is illegal because it's unconstitutional, and that's an argument that Lawrence Tribe and Peabody and others have been making more adamantly than others, although it's still in the industry briefs at the D.C. Circuit. And then B here is the 112 verse 111 issue, and whether the Clean Power Plan is legal given that power plants are already regulated under Section 112 of the Clean Air Act. And then the remaining 4 are the building blocks that were in the proposed rule, which Clint mentioned already. F is no longer a building block, and you can see that that was a good decision by EPA, given that, at least from our survey results, F was what the folks thought was most unlawful. And then E is the idea of going outside the fence line and shifting generation, requiring owners of coal plants to essentially stop operating their plants and substituting renewables for that. So with that, I'll turn it over. Hopefully Sean's back, and Clint can introduce Sean Donahue.
Great, thanks, Brian. And our last speaker is Sean Donahue, is an attorney with the firm of Donahue and Goldberg, which has offices in Washington and New York. Previously, Sean spent several years in the appellate section of the Department of Justice's Environmental and Natural Resources Division, and he also clerked for then D.C. Circuit Judge Ruth Bader Ginsburg, as well as Supreme Court Justice John Paul Stevens. He's a graduate of the University of Chicago Law School, and you can find out more about Sean at his firm's website at donahuegoldberg.com. Sean?
Thank you very much, Clint, and thank you everyone for participating. So I will just say a few words about sort of my big overall sort of perspective on this rule, and then I can maybe say a few things about where I think the litigation may be going. I represent the Environmental Defense Fund in the D.C. Circuit litigation, which is a respondent intervener supporting EPA. So first of all, it's worth noting that the problem of climate change is continuing unabated. In 2009, EPA made a finding that emissions of carbon dioxide and other greenhouse gases endanger public health and welfare. And that triggered regulation of emissions from automobiles, which EPA proceeded with and which was upheld in the courts. The science and the evidence, and in fact the temperature since that 2009 has all been building up, and the basis for action under the Clean Air Act is every bit as strong and stronger as it was then. And EPA has an obligation under the Clean Air Act to regulate dangerous air pollution. So the question is, and of course power plants are the single largest source of greenhouse gas emissions from the United States, bigger even than the transportation sector that was the subject of the Massachusetts versus EPA decision, and that EPA has proceeded in a set of rulemakings over the last several years to address. So the question arises, sort of what's the best tool in the Clean Air Act to do that? And I think there's a compelling case that the statutory tool EPA is using in the Clean Power Plan, Section 111D, is in fact a really sensible one. And it's worth pausing for a moment and remembering that the Supreme Court's second case, the next one after Massachusetts, dealing with greenhouse gas emissions in the Clean Air Act, was the American Electric Power case, where a number of states sued power companies and argued that there should be a remedy under the federal common law of nuisance for the very large volumes of CO2 that these existing power plants were emitting. And at the suggestion of the defendants in the case, the power companies, the Supreme Court denied relief and said there isn't a federal judicially created remedy for this pollution. And a large part of the court's analysis was this is something the Clean Air Act specifically addresses, and the court pointed to Section 111 and Section 111D in particular and said that provision speaks directly to these emissions, and EPA has the authority to regulate under it, and EPA has some discretion about how it does it. And so what EPA is doing in the Clean Power Plan is following up on that discussion and the unanimous AEP decision. I'll just briefly say a few things about the rule itself. We think the lawfulness of the Clean Power Plan should come down to not a poll of people ultimately, although that's very interesting, or polls of judges, but analysis of what the statute says and what the record says, and we think that's sort of what EPA did here, is apply the language of Section 111D and some key terms like best system of emission reduction, adequately demonstrated, considering cost, to the facts about how the power sector works, how these sources operate in fact. And we think that's what the extremely large record in this case is, as EPA is applying the statute to the facts. And we think the rule is consistent with and based upon things that have already been going on in the sector. I think the figure 30% reduction in emissions has been mentioned, and that's measuring from 2005, which is a metric that's used for reasons of international climate discussions. But we're already about halfway there based on very large reductions that have occurred over the last decade, largely due to the economic forces that have made natural gas much cheaper than coal, and natural gas plants emit about half as much as coal plants, and then the growth of renewables. So we think the rule sort of mimics and tracks what the market is already doing, and we think EPA applied those statutory terms to what it observed power companies and states doing already to reduce carbon dioxide emissions from power plants. This rule is about emissions control. It's not about EPA's preferences about how electricity should be generated. It's about how dangerous pollution can be reduced from a particular source category. And that's sort of the central thrust of it. And we think there's been a very effective and eloquent and skillfully presented sort of campaign to characterize the rule as something aberrant and bizarre and over the top. But we think the more one looks at the rule and the more courts look at it, the more it looks like an agency sort of earnestly trying to apply law to facts. And in fact, in key respects, it's not so very new at all. The daily, in fact, minute-to-minute practice of shifting generation among power plants has been a key factor in other regulations under the Clean Air Act of this sector, including a succession of rules under the Interstate Air Pollution provision in Section 110, which similarly took account of the fact that very often the cheapest way to reduce emissions and the most convenient way is by shifting generation from relatively high emitting sources to low emitting sources. I guess I'll point to one interesting feature of the case, which is that many of the challengers urged that the way that EPA was setting the stringency of the emissions targets in the rule by looking at the building blocks that Clint described is totally illegal and very much against the paradigm. And I think Jeff kind of described this view and endorsed it in his remarks, that this was completely not what Section 111 really has in mind, completely illegal. But once you set the targets, please let us comply this way. Let us use these cheap mechanisms of shifting generation and flexible compliance approaches. We want that for compliance. And one question in the case is, if this is indeed what is actually pervasive in the industry, and indeed what the industry wants to do to be able to comply much more cheaply than a strategy based solely on within the fence line measures would imply. If that's true, then what in the language of the statute or precedent or otherwise forbade EPA from considering it as the best system of emission reduction? And that's something we'll have to see, and that'll be a major topic, I'm sure, at oral argument. But there's a kind of disconnect between these sort of technical statutory arguments and the sort of usual, both the actual practice in this sector, daily operations of the interconnected grid, and the usual sort of regulatory arguments of industry. I think there's one interesting amicus brief on EPA's side from Dominion, a power company in Virginia that owns coal and gas plants, sort of pointing out this concern that the statutory arguments that the challengers are making here about the alleged impermissibility of considering generation shifting and setting standards, the concern that if that were really true, it would not be in the interests of industry. It would create it would increase cost and diminish flexibility, and Dominion says, this is a rule we can work with, and if we have the flexibility that EPA said we have, then we'll be able to do it. And I think when you get behind the rhetoric, this rule is a reasonable, sort of moderate, phased in over a very long period way of implementing the Clean Air Act's obligation to deal with this dangerous form of pollution. And with that, I look forward to the discussion and to questions. Thanks.
Thank you all for being on our panel today and for those great introductory comments. This is Liz Evenson. I'm the Director of Energy and Environmental Policy at CSG. And Clint and I prepared some questions for you three. So we're maybe going to spend about 15 minutes giving you guys some of our questions, and then I'll turn it back over to Clint, and we'll answer questions from the audience after that. So the first question we have is, what are some key legal arguments for or against the Clean Power Plan that are not receiving sufficient coverage? And why don't we start with Jeff? Jeff, are you there?
Yes, can you hear me?
Yeah, or you might have been on mute. We can hear you now. Thanks.
I'm hesitant to say that any arguments haven't received sufficient coverage because there's an awful lot out there about all of these things. I guess the one, and this is maybe only interesting to administrative law lawyers, but one of the issues that will be really interesting before the D.C. Circuit is the argument that the EPA finalized a rule that it really didn't propose. As some of you know, the final rule is really, very different in pretty fundamental respects, and traditionally under administrative law, you wouldn't be able to do that unless the final rule is a logical outgrowth of the proposal. There's things that EPA disavowed in the proposal that they did in the final rule, and EPA's position is there's a unique provision of the Clean Air Act that basically lets them do that and says the only remedy if we finalize a rule that we didn't propose is for you to submit a petition for reconsideration. I think that administrative law issue may be interesting to some of the D.C. Circuit judges, and such as Judge Tatel, who really cares a lot about ad law. And so there's a possibility that you would get a decision that says, you know, we're not going to pass on these ultimate legal issues because EPA, you've got to give people a reasonable opportunity to comment on the type of rule that you're actually going to finalize. So that's one issue I would point to that I don't think has gotten a lot of attention, but may ultimately be important, at least in the DC Circuit.
Great, thanks. And for the rest of you too, if you think, like Jeff did, that everything has gotten a lot of coverage, which maybe it has. Maybe, like Jeff said, if just an argument that you feel is incredibly interesting too would work. So Brian, what are your thoughts on that one?
So I have two quick things, and these are really, you know, like with Obamacare, if the Clean Power Plan gets upheld, I would expect subsequent cases based on that could impact the legality of the Clean Power Plan itself. And so I thought I'd mention those. And the first has been talked about, but it seems to be forgotten a lot, and that is the 111B rule and EPA's decision to require carbon capture sequestration for new coal plants. Under 111D, the section provides that you can only regulate existing sources, which is the Clean Power Plan, if there is a 111B standard in place for that same source category. So that challenge is coming up in the DC Circuit, but is a little behind, I believe. Although now that the en banc has been moved, I don't remember the exact date, and maybe Sean or Jeff can chime in on that in a little bit. But if the court, even if the DC Circuit were to uphold the Clean Power Plan and the Supreme Court, if in the end the Supreme Court says the 111B is unlawful, rule is unlawful, that could at least put on hold the Clean Power Plan until EPA rewrites the 111B rule. And the other sort of later suit that could come is when the EPA finalizes its federal implementation plan. And the one issue that I think is the most interesting, and it is raised in the Clean Power Plan litigation, but it's sort of a minor argument or not focused on as much in the brief, and that is whether the Clean Power Plan violates the 10th Amendment. The 10th Amendment provides that the powers not get delegated to the federal government by the Constitution are reserved to the states, respectively, or to the people. And basically, as the Supreme Court has said many times, the federal government can't compel states to enact or administer a federal regulatory program. Otherwise, the federal government's actions violate the 10th Amendment. Now, in the briefing, industry has argued that the rule is unlawful because it's essentially commandeering states' abilities to regulate their own electricity sectors. And I think my personal opinion is that argument is a bit of a stretch and not the best of the arguments the industry is making. But I think if EPA finalizes a federal plan that makes the federal plan significantly more onerous for states than state plans, you might see 10th Amendment challenges to the federal implementation plan. So those are my two, and I'll see what Sean thinks about that.
Okay, great. Sean?
Sure. So on the question of the timing of the 111B case, Brian's right that it's on a little bit slower track. It hasn't been briefed yet, and in fact, there's some question that the briefing schedule may get pushed back a little to adjust for challenges to reconsideration denial. So that case will be briefed this late summer and fall probably, and then argued on a several months after the 111B Clean Power Plan case about existing sources. So I think this question of whether there is a contradiction or a sort of tension between the I will call them technical statutory arguments that are the sort of central theme of this challenge to the way EPA set the emissions targets, the building blocks. The tension between that and the sort of undeniable preference and comments and decades of history of industry for compliance flexibility, and the sort of the proper role under this statute and its sort of broad language of considering things that would certainly be used. I mean, EPA in this rule said several times, like they said, they did look at measures that could be carried out, solely on the physical premises of each plant, like co-firing of coal plants with natural gas, which can reduce emissions significantly, carbon capture, retrofitting plants to capture carbon at existing sources. And EPA said, we could, those would be more expensive than the measures that we identify as the BSER. We could do it, but if we did a standard based on that, everyone would want to comply by the kinds of measures that we're in fact relying on generation shifting. So one thing I'll be interested in is whether this aspect of the case reminds me a little of some of the arguments in the EME Homer case, other major Clean Air Act case in the Supreme Court, where the challengers challenging this interstate air pollution rule had sort of statutory arguments that said that the statute imposes more rigor on how EPA can sort of set emissions reduction requirements. And the court sort of played around with the statutory language, and ultimately I think, and this was not this was, I think, it was a 6-2 victory for EPA. The court ultimately sort of concluded, no, there's not a statutory prohibition, and this makes a lot more sense. And it's actually a lot more efficient than the alternative. And I think there's an awful lot of similarity here, and the question is whether the petitioners will be able to conjure up a statutory prohibition against this approach, which we'll see. But I think that tension between sort of compliance and setting of goals is something that I'll be interested in at the argument.
Okay, great. We have a lot of our members on the call, which are employees of state air agencies or state legislators, and so for those folks, and given a lot of the key uncertainties that we've talked about on the call so far, what advice do you have for state air agencies or state legislators in 2016, 2017, and 2018, given where we are in the Clean Power Plan at this point? And let's start with Brian this time.
Well, to be frank, you're in a tough position if you're a state regulator right now, because if the Clean Power Plan happens in a lot of states, it's going to be a really big deal. And trying to figure out and plan utility infrastructure takes a long time, especially to build new plants or new transmission lines. And so, while on the one hand you don't want to spin your wheels for nothing if the rule was to get overturned, on the other hand, you don't want to be left holding the bag. So, at the end of the day, I think I've always advocated that planning is better just in case. Waste, if you were to waste the resources planning for a rule that got overturned, that the cost of doing that would be a lot less than having a plan in place and being ready to go rather than being left flat-footed, so to speak.
Sean, what's your take?
Yeah, I mean, I would agree with Brian, and I also think before this rule and after this rule and whatever happens to this rule, fossil generated power is going to be entering an era where it's not already of being constrained for carbon, and that's just happening, and that's from multiple sources, many quite independent of the federal government, that's happening. And so I think states are, and this is I know happening throughout the country, states are well advised to be thinking about that and working toward the kinds of steps that will facilitate that. There's a lot of opportunity there, upside, and so I think And I completely think that the Clean Power Plan is an important part of that, but not the only part of it, and it makes a lot of sense to continue thinking about how to bring that about in a way that works for everybody. I would also say, believe it or not, I don't agree with Jeff about what the stay means for the Clean Power Plan coming into force after a stay is vacated after either a merits decision for the Supreme Court or a motion for that relief that the Supreme Court would grant. I don't think the court got into the minutia of what happens, particularly with the 2022, commencement of the actual compliance period. I can say with great confidence that the justices were not thinking about that. There certainly can be arguments that, oh, you need to move everything back, and these kinds of issues have been played out before, but I don't think in the context of a rule that provided this sort of very, very unusually long phase-in period. So, well, I think some of the deadlines likely will be moved. The idea that everything, in particular the compliance period, will be pushed back, I think is I don't agree that the Supreme Court has decided that, and I think if the courts uphold the rule on the merits, there'll be a very strong case that that the 2022 is still the beginning of the compliance period, and state planning can be accommodated in the interim.
So is it my turn? Can I just make a quick point?
Yes.
I understand why Sean is saying what he is saying, because the EPA is also doing the same thing and wanting to basically hold this threat over people's heads. It is a completely empty threat. There has never been a case where a rule has been stayed and then put back in place where all of the deadlines weren't pushed back. And there is no way that the courts are going to effectively penalize states and companies for relying on the fact that the rule was stayed. So anyway, I understand why Sean says what he does, but I think it's just incorrect as a legal matter. And if you go back and look what EPA said to the Supreme Court when they were objecting to the stay, and I actually think I have that quoted on a slide, to slide 24, EPA itself acknowledged that all of these deadlines would be pushed back. So that's one thing I'm very confident in saying, and that is that the courts are not going to penalize states or companies for not continuing with their planning activities and doing all the things that would otherwise be necessary. So if the rule comes into effect, ultimately the deadlines will all need to be pushed back, and they will be pushed back.
All right, I'm going to note my disagreement with, there are a few examples from the Clean Air Act, but they all involved of stays that were dissolved, but they all involved deadlines that were much more, and often had already passed by the time the court acted. There's nothing like this, and so the suggestion that the Supreme Court has already decided that 2022 is going to move, I think, is just not correct, and I'm sure there will be vigorous arguments about it, but I don't think that that's a conclusion one can draw from precedent or any source of law. So, and of course, there's also the argument that the actual compliance date is 2030, and even under the plan as with the time frames pre-stay, states actually didn't have to achieve emissions reductions in 2022. You could kind of backload it. So that question will arise. What are the consequences for final compliance? But I'm sure that what courts will want is questions like this to be resolved in light of, first of all, the sort of facts on the ground, and then arguments and sort of information about the equities on both sides, including the hazards of further delaying actually cleaning up the pollution. And I don't think we can say that the court's terse stay order is more than it is.
And I would just add that I think even if the rule is delayed after, as Jeff, you know, strongly says it will be, and I'm kind of in between the two on that. I mean, I think it could go either way, but if it was pushed back, I still think the amount of time necessary to come into compliance in some states and the lead time for utility planning says start planning as soon as possible, because these decisions, you know, building a big transmission, 100, 200-mile transmission line can take 10 years to get through the regulatory approval and routing and siting process and building. And so I don't think there's any real reason to wait.
Great, thanks so much. And this is Clint with APCA, and I think we're going to shift to a few audience questions, several of which dovetail with a few of the questions that we've submitted in advance. And I think maybe we'll combine a few here, and I think Brian addressed this issue a bit, but wanted to ask you all what in particular you'll be looking for, not next week, but in late September when the DC Circuit holds oral arguments on the Clean Power Plan. And then similarly, do you all see the May 16th DC Circuit order impacting the timing of a future decision by the court, or the likelihood that the Clean Power Plan would be upheld either by the DC Circuit or the Supreme Court? Maybe I'll turn that over maybe first to Jeff.
Sure. You know, one of the arguments that EPA makes, and that Brian has made, is that that Sean has made, is, you know, this is just another EPA regulation. This is just EPA applying the law to the facts, and they come up with this regulation. I think that argument is difficult to make now that we have these two really extraordinary steps where, you know, the Supreme Court thought that these issues were serious enough to stay the rule, and then the DC Circuit thought they were serious enough that they ought to have a full en banc hearing. So I do think that at least with respect to that argument that this is just another, you know, run-of-the-mill EPA regulation is a pretty hard argument to make. And so I do think that is changed by virtue of the fact that the court has now said, you know, we're going to argue this in front of the full en banc court. In terms of what I'll be looking for in the oral argument, this may sound kind of silly, but I'm going to be eager to hear everything that everyone has to say. You know, you often get some sense as to where a judge may be coming from, what his or her concerns may be, and so it's not as though I go in ahead of time with a list of things to look for, but I'm going to pay pretty close attention to every one of the questions that we get from this 9-judge court, as well as the answers that are given. And I would say we still don't know whether this is going to be a one-day argument or a two-day argument. We're still waiting to hear back on a briefing order from the court, so it may actually be September 27th and 28th.
Great. And Sean, do you have comments on that question?
Sure. I mean, and this will be the last time I quibble with Jeff to start off my bed. Just I didn't mean to suggest that the Clean Power Plan is run-of-the-mill or minor. It's very important. The problem's very important. The industry, you know, touches everybody and is critical. And this rule is unusually long and complex. There's no dispute about that. My point was ultimately the EPA's charge is to apply the law to the facts and come up with something, and the question is whether that something is reasonable. So on the en banc order, you know, I think we're all speculating, but if you think about what the panel was looking at, with knowing that the Supreme Court had expressed interest in this unusual way, and I fully agree with the comments that the stay was unusual and exceptional and unprecedented in lots of ways, you basically have a very unusually high likelihood of Supreme Court merits review, and with a pretty good chance that there would at least be en banc petitions in between, and maybe en banc review. And so it makes an awful lot of sense sort of, in a case where I think both sides agree there's a very high interest in moving things along, certainty for everyone. If there is a problem with this rule, we need to do something else to address the problem, and there's deadlines in the rule, and et cetera. So I think it made considerable sense for the court to say, for the panel to say, maybe we should move right to en banc. And this is a mechanism that is in the Federal Rules of Appellate Procedure, is not used very much. So I think it made some sense from judicial administration, and sort of what it means, you know, for the two sides and their relative advantages and disadvantages, we'll have to see. But I think it makes sense. And while there's a delay of a few months, we would be having oral argument next week if it were on the old schedule, and it'll be late September under the new. I think the likelihood is that this procedure will expedite the time that we have a sort of definitive final ruling from the courts on the Clean Power Plan, and so that's, you know, probably a good thing. That may be something we can all agree is a good thing. And I think, yeah, the oral argument, I'm completely with Jeff. You know, everything will be interesting. With a 3-judge panel, you can kind of especially over a many-hour argument like this, you can kind of get a feel of where judges are perhaps leaning, or what their feelings are about the case. Here, where we have a much larger number of judges, it'll be a challenge, and it'll keep people awake in the multiple hours of argument. And where things stand on that is the two sides submitted proposed argument formats to the 3-judge panel, and they were not terribly different, but basically the petitioners wanted a little more time, and they wanted to do it over 2 days, as Jeff mentioned. And there were a couple of argument segments that they wanted to add that not everyone was in agreement were needed. And those, and then EPA's proposal had, I think, something like 3.5 hours of argument total, which is exceptionally long, but less than the petitioners were suggesting. And those dueling proposals are still outstanding, and now we're before the en banc court, so we don't know if the court will act on those or set up some other approach, but I'm sure it'll be a longer than usual argument.
So I'll jump in and on the argument.
And I'll ask you just one follow-up question, Brian, and maybe you're going to tackle this, but is there any particular judge whose body language you'll be paying attention to for the oral argument?
Yeah, that's exactly what I was going to say. So I'm going to be watching Srinivasan the most. Obviously, you got to pay attention to all of them. But, if there ever were a case where political backgrounds of the judges matter, this is it. I agree with Jeff, and he said this at the beginning of the call, that, if this case wasn't about climate change on the law, I don't think it would be a close call. But it is about climate change. The case matters a lot because of the climate change implications in the Paris Agreement. And right now you've got 9 judges, 5 of whom were appointed by Democratic presidents. And of those 5, I think Srinivasan is generally viewed as the most, the administrative law expert, the most even keel as far as politically. And, he was confirmed, I believe, fairly unanimously by the Senate not too long ago. And he's an administrative guru. So, and, I think this is not a typical, I disagree with Sean that this is a typical reading of the Clean Air Act or administrative rule. It's not. It's a pretty drastic reading of the Clean Air Act, but, EPA is smartly saying in their briefs that there's a good reason why they're taking this reading, and that's because they think climate change is so important.
Great. Any other follow-up comments there? And we had just a couple other questions that I think we've got time to get to here. One being that EPA throughout the rulemaking process has made an argument about severability And I think states are well aware that for many Clean Air Act rules, it's often not all or nothing in terms of court decisions. And in light of Brian's survey and some of the more legally vulnerable elements that have been identified on this webinar, I wanted to ask if you all could maybe take a stab at whether or not it's possible that that portions of the rule be upheld, and maybe what the most likely form things may come out of the D.C. Circuit or the Supreme Court over the next few years that maybe states as they're trying to figure out what they're where they're devoting resources might want some additional intelligence on. Is there a different form this rule may take as a result of remand, or any other comments you all might be willing to make there in terms of some portion of the Clean Power Plan being upheld and maybe other portions being changed down the line? And Jeff, maybe we could turn to you first.
Sure. You know, the thing that I think has been discussed most often is that building block 1 it basically reflects the way that that Section 111 has always worked until now. So, you know, for the last 47 years, what a standard of performance is something that can be used at an individual facility to reduce its emissions rate when the facility is operating. I mean, that's what a standard performance is in 100 and some odd new source performance standards. That's what it is for new coal-fired power plants. And, you know, the addition of building block 2 and 3 is what makes this so unusual. So some people have argued that that the court could simply eliminate building blocks 2 and 3 and leave building block 1 in place. I actually I think we could certainly get a decision along those lines, but even so, I don't think that means that the rule, you know, that part of the rule would just remain in effect. You know, EPA has been pretty clear in saying, you know, the 6% heat rate improvement target is part of this system. And so even if, you know, a state can't necessarily get 6% across all of its plants, it could get a little more from building block 2 or building block 3. So even if we get that decision, which says EPA can use Section 111D and they can use building block 1, I still think that would need to be remanded, because EPA has not really done the kind of technical work that would justify, you know, a 6% improvement across the board. And also, you know, if this is something that's applied to an individual plant, it's also clear from the statute that states are given discretion in applying a new source a standard to any individual source. So this is a very long way of saying I think it's pretty unlikely that we would get a decision that would just lop off building blocks 2 and 3 and leave building block 1 in place. I think even in that case, it would be remanded and EPA would have to come out with a new rule.
And I agree with Jeff's ultimate conclusion. You know, when EPA in its proposed rule, it made it very clear that the building blocks were severable, and if one was overturned, it even had tables that showed what the new requirements would be for states. And then, for whatever reason, well, I think I know the reason, in the final rule, EPA tied them all together and basically said if any of the building blocks or 2 or 3 are thrown out, then 1 is also thrown out. And so I agree it would have to be remanded. My thoughts on why they did that is they didn't want to give the courts an easy way out where they could still leave a rule in place, but it would just be less stringent. So I think, you know, as we talked about on the call, they know that the policy implications of this are probably their strongest argument, and so that's my guess as to why they reversed course and didn't make them severable.
Yeah. So I would just add, this is Sean, that you know, if the court were to find that the generation shifting building blocks 2 and 3 are impermissible, EPA would be left with a situation where they determined that the best system of emission reduction included those elements, and indeed most of the emission reductions under the rule are attributable to those. EPA would have to reconsider what is the best system. And as I mentioned, EPA did look at things like co-firing with natural gas and carbon capture and sequestration as, possible alternatives, but EPA said, no, those are more expensive than generation shifting. Not necessarily unlawfully expensive, and obviously a component of what's the best system of emission reduction is what will achieve meaningful reductions in pollution. So a possibility would be EPA would have to look at what kinds of on-site measures are in the BSCR, including co-firing. And then the question would arise, how did the court write its opinion? Did it write its opinion in a way that would allow generation shifting for compliance, or does it take a very, very strict view of some of the petitioner's arguments and say that no, not only must the goals be set in light of on-site measures, but compliance from the resulting standards of performance always has to be on-site, and that would be, I think, a Pyrrhic victory, because it would be more expensive and less flexible, and not what anyone wants. So, so we'll see, but I do agree that simply picking the building block one is not a viable solution.
Great. Well, this is Clint again from APCA, and we've reached the end of our 75 minutes for this webinar. But I wanted to first and foremost thank Sean, Brian, and Jeff for sharing their expertise with the many state officials who are joining us on the webinar, and thank all the participants who joined in, as well as the Council of State Governments for co-hosting this webinar with APCA. All attendees will be receiving an email that should have a link to the webinar proceedings, as well as slide presentations. There's a few slides we didn't get to as part of this discussion, but I think will be some helpful background information. And again, there'll be some other information available on CSG's Knowledge Center at csg.org, and should be some additional information on APCA's website at cleanairact.org. But thank you again to Sean, Brian, and Jeff, and to all of the attendees for today's webinar. We'll look forward to speaking to you all soon on the Clean Power Plan and other topics. Thank you.